Hello everybody, my name is Yehuda Raskin, the co-president of the Fordham Hetero Society. I'd like to thank you, welcome all of you today to our event entitled Reproductive Justice and Religious Liberty. The Federal Society for Law and Public Policy Studies is founded on the principles that the state exists to preserve freedom, that separation of governmental powers is central to our Constitution, and that the duty of the judiciary to say what the law is and not what it should be. The Society seeks both to promote an awareness of these principles and to further their application through its activities. I would like to thank the co-sponsors for today's event, that's the American Constitution Society and their president, Alex D'Amico, as well as the Law Students for Reproductive Justice and their president, Emily Wolf. I would also like to thank my co-president, Dalia Galgis, who, despite being displaced by Hurricane Sandy, has worked hard to bring this event together. I am happy to welcome today's speakers, Professor Richard Epstein and Ms. Bridgette Dunlap. Professor Epstein is the Lawrence A. Tisch Professor of Law. I'll make it quick. At New York University School of Law, adjunct scholar at the Cato Institute, and the James Parker Hill Distinguished Service Professor of Law Emeritus and a senior lecturer at the University of Chicago Law School. Ms. Dunlap is a Human Rights Fellow at the Leitner Center for International Law and Justice at Fordham Law School, former Crowley Scholar in International Human Rights, and the former president of Fordham Law Students for Reproductive Justice. We're going to start off today's debate with a 15-minute opening by Professor Epstein, followed by 15 minutes by Ms. Dunlap, and then a 5-minute rebuttal for each side. We're then going to have an opportunity for questions and answers from the audience. Questions from the audience, answers from the speakers. I will pose the following question to Professor Epstein and Ms. Dunlap. Okay. The Patient Protection and Affordable Care Act mandates contraceptive coverage for all employers and educational institutes. The mandate applies to all new health insurance plans. It controversially includes Christian hospitals, Christian charities, Catholic universities, and other enterprises owned or controlled by religious organizations that oppose contraception on doctrinal grounds. President Obama has instituted a 1-year safe harbor during which the religious accommodation will continue to be negotiated. But in the meantime, several religious organizations have filed lawsuits challenging the contraception mandate, and its future is uncertain. This provision has brought a focus to the question of how religious liberty should be allowed to shape and impact public policy, including healthcare. I'm going to ask both of our debaters to discuss for 15 minutes the tension between contraceptive coverage and religious liberty, and what result they believe will emerge from the various lawsuits filed over the mandate. Professor Epstein, I turn it over to you. Thank you.
It's always happy to be here. As I tell my students, whatever I believe will not be the law of the land, so I have no confidence that any argument that I'm about to make will be accepted by any working or practical judge. Now, why is it that I take such a dim view of my chances? It's because I do not begin the question of religious liberty with a discussion of the question of religious liberty. I begin the discussion of religious liberty with the question of what it is that we mean by liberty more generally, and then treat religious liberty as a subset of that issue. And then, the last stage of the argument is to figure out if the general arguments in favor of liberty tend to be eroded, do arguments for religious liberty still survive? And in this particular regard, I am, in fact, quite unregenerate. I think, in effect, the general notion of liberty carries with it several important correlative duties. The first feature about liberty is that I have a liberty of action, which means that other people by force cannot restrain me in what I do, so long as I by force do not try to force them to do something against their will. And the first and most important principle of liberty is that of mutual forbearance of force by all individuals at all times against all other people. And the way you test the salience of that provision is to ask yourself what happens in this or any other world if that particular prohibition is violated and you have, in Hobbesian terms, the war of all against all. So the next question then is, how much further does liberty go? If you start simply with the rule of non-interference with the person and property of other people, there is always the question as to whether or not these people can combine their resources in order to cooperate with one another, so as to get out of that joint venture greater gains than the costs that go in. And this is essentially comes under the heading of liberty of contract, that is voluntary arrangement between individuals are generally presumptively accepted, of which freedom of association is a subset. And the difference between them is that liberty of contract includes all sorts of spot arrangements like contracts for sale and so forth. And freedom of association can cover joining in religious groups, and as an intermediate case, you have complex employer-employee relationships where you have employers of all different kinds and employees of all different kinds. And the question is how these employers and employees get together. And the general argument about freedom of association is that unless people have the right to refuse associations with other individuals, you will never be able to get yourself an association that works on rough pattern. And so workers have a right to quit, employers have a right to fire, individuals have a right to join organizations, they have a right to quit. Organizations have a right to exclude. Is there any exception to this principle? And the answer is there is one. And it's important to explain why it is not relevant in this particular case. The general exception is if you are running a common carrier. And the question is whether or not you're then under duty to take all customers at reasonable rates in order to make sure that they can go from this place to that. And it has generally been held that where you have competition, the absolute right to refuse is perfectly appropriate. Where you have monopoly power, it turns out that that right is known. Now, if you apply this position with respect to the way in which we deal with contraception and so forth, and wholly ignore the religious implication, the first thing we have to say is it's almost impossible in any employment market to find anybody who has anything close to a monopoly position, so that the whole common carrier portion of the discourse just simply drops out. So at this point, it's now a freedom of contract type situation. And so the question is whether or not somebody has the right to refuse to deal with anybody for any reason at all. And if you go back to the common law principles which maximize gain from voluntary association, the answer is you always have that right on both sides because there are a sufficient number of alternatives available to people on both sides so that if you don't get the job that you want with one group, you can go to another. Well, what does this encompass? Well, there are certain side constraints having to do with bribery and things of that sort of public officials, not an issue here. But generally speaking, if I'm an employer and I want to tell you I'm going to provide you with health care coverage under the following terms, A, B, and C, and you can come, take it or leave it, you are entitled to reject that offer, you are entitled to accept that offer, you are entitled to make a counter offer one way or another. And if in fact that now happens, the agreement that you get, generally speaking, will work to the benefit of both sides because neither can impose unilaterally terms upon others. So now if we just look at this in the general way, what does this mean with respect to contraception? It means, in effect, that you have an employer, even though one with no particular religious interest whatsoever, who decides that it does not wish to cover these kinds of benefits. It is perfectly within its rights to do so. And men or women or both who disagree with the policy can resign either singly or in unison in order to express their difference. The key point to understand about this is that the only right that the employer has is the terms that he can offer his people. He has no right to coerce people to take their particular jobs against their will and then take the limited coverage that he wants to offer. Now, if it turns out, the question is what goes on in the opposite direction. Can a woman or a man come forward and say, look, what we would like in a world or in a free society is to work for you, and we want you, in effect, to supply us with certain kinds of benefits, whether you want to or not. And the answer is freedom of association means that the employer can retreat for the same reason that the employee can retreat, because they don't want the particular benefits in question. So you have to understand that the right to withdraw does not count as some form of coercion. And so it becomes very important to understand in this situation what it is that we mean. And I'm going to quote here from a prominent statement made by many professors in support of the Obama mandate, which says, the egalitarian solution, a dangerous word, that every American deserves to enjoy religious freedom is under attack to those who would cede employer religious rights to corporate executives and nonprofit directors. It would be absolutely incomprehensible for me to think that when the Catholic Church decides that it does not wish to supply contraception because it's inconsistent with its own religious beliefs, that what it's in effect doing is telling any women, including those who turn down their job, that they cannot get this from other kinds of sources. And in fact, in this case, the religious organizations generally are more tolerant perhaps than they should be under strict religious teaching. In my view, they are perfectly entitled to say, we will not hire any women who use contraception. And then if the women don't like it, they can go to other places. My own advice to them as a business matter is you want to take that position up, you can commit economic suicide on your own time, because what will happen is you will find that there will be retreat en masse. But that only reinforces the point because it shows the power associated with the exit right under these circumstances as a powerful constraint upon the way in which employers start to give their terms. There is no dictation in the competitive market. There are terms that you can propose and be rejected, and in fact, if you impose those terms which are so utterly unpleasant with respect to the people that happens, the exit right becomes devastating because you can no longer deal with your situation. And then in effect what they say, this cramped and one-sided view of religious freedoms Supervisors are entitled to decide based on their religious sentiments, that's a wrong word, it should be principles, whether employees will be permitted to join essential health benefits, that's a statutory term, without the slightest concern for their religious beliefs. Well, that's not what's at stake at all. What's at stake in this particular case is whether or not when you turn the ship around, a person can come and say, look, we now have a general rule and non-discrimination law in employment, which I think are desperate mistakes and have thought so for a very long time. You now are going to be forced to hire us because you can't discriminate against us on the grounds of sex. And now that we're here, we are going to tell you that since our liberty is important, we can now force you to provide for benefits which go against the kind of conscience that you have. So the question you have to ask in this case is, given the general pattern of free association, who is it that is basically coercing whom? And in these particular cases, the coercion comes essentially from the women who claim that they're the victims of a war that are being lodged against them by religious organizations. And the simple explanation about this is that we now have a situation where first wrongly in my view, we force this sort of involuntary association on people through the anti-discrimination laws, and then in the second stage say, now that you don't have the power to dismiss anybody, we tell you the kinds of benefits that you have. To me, this is an intolerable form of coercion that destroys mutual trust and cooperation in individuals, wholly without regard to religious liberty. So the question that then becomes most urgent in these cases is what happens, as always happens to my views, is that to some extent you lose on the general discrimination. That is, my position is in voluntary competitive markets, no monopolies involved, these laws are in general a mistake. And now the religious people find themselves in a very awkward position, because what they have to do is not claim the general rights of association that I believe is a matter of first principle given to all individuals. What they have to do is to explain why it is that they're special, and that religious organizations can turn down things that other employers, in fact, are required to accept. That's the baseline politically under which everything is being argued today. My position is it's the wrong baseline. But if it is, in fact, the baseline, you run into the following really very difficult and kind of awkward situation. If you say, in effect, that these religious organizations have such powerful beliefs of conscience that they should be exempt from the general law, there is always the argument that that special form of privilege counts as a kind of an establishment of religion because of the preference that it gives. But on the other hand, if you decide that they have to take these people so they are in preference, then in effect it looks as though it's a genuine coercion against the free exercise of religion of these organizations. So what you do in effect is you completely make the intellectual debate largely incoherent by virtue of the fact that you accept the wrong baseline for analysis, which is the normative probity and the normative soundness associated with the general rule, which says in these circumstances, religious liberty, right, the term that we're talking about here, has to go from a baseline under which the anti-discrimination law turns out to be the basic norm. Now, why is it that I think that this thing will have consequences which in the long run none of us will particularly like? And I think the explanation goes again to sort of the technical theories associated with contract and has nothing to do with my religious beliefs one way or another. But basically what happens is an effective system of voluntary organization works on the following premise. We try to reduce the cost of transactions that allow people to get together so that we can, in effect, maximize the gain. One of the reasons that we know that markets tend to work well on a voluntary basis is that if you get the right to choose your trading partner, all the cost of enforcement that the law is going to have to supply to you will become less important because the social sanctions based upon trust and common interest will work much better to deal with the situation. The moment you start dealing with situations where there are forced requirements that one person supply another person with any kind of benefit and cannot remove them from the particular job, what happens is the enforcement costs go very heavily upward, and in effect the gains that you get from these transactions will start to go down. Now what does this mean? Well, it means that one of the problems that you associate with the Obamacare legislation, the ACA, is that what it will do, not only because of this provision, but because of all the provision it takes, is it will lead to a systematic reduction in the number of employment relationships that take place in virtue of the fact that the gains from trade will be eroded by the coercive litigation. So you're going to say, oh, this is just terrible academic folderol by an old guy who really doesn't understand what's going on. You know, in a sense, I really don't understand what's going on. But in a sense, I do. Because if you looked at the last day's paper, you already discovered that in an effort to get rid of the entire mandate, what has happened is many employers are shifting to contracts in which they only take people for 29 hours a week, because they know once they hit that magic 30 number of hours, they are then going to be in the place of mandated employment. And if you look then at the general nature of the recovery, the so-called 5,000 million jobs created in the last 2.5 years by the president, what you discover is that most of these are part-time jobs, or a very large fraction are, precisely because all of the oppressive restrictions that you put on employers has resulted in a reduction overall in the market. Now, there is nothing about the religious mandate, there is nothing about contraception, which is distinct and special, and is somehow or other immune, therefore, from these general pressures about the dangers that are associated with coercion. And so, what it is, in effect, is it's a very odd, almost perverse view in my sense, to say that what you do is you have claims of religious liberty on both sides, so that unless I can force an employer to do what I want him to do, I do not able to exercise the religious liberties that I have. This is a view of the world which means that no matter which way you come out, somebody's necessarily going to have to sacrifice religious liberty. And the more rational and sensible way in which to deal with this general problem is to develop a conception of liberty, which means that it's not my liberty or your liberty, but it's a way in which we can satisfy the liberty of both. And if you start using this view of employment arrangements, which in effect has this coercive element in it, since you get the employment law wrong as a normative matter, you'll always come out with things. So let me just end by giving you one other sentence. In particular, advocates claim that the Constitution gives all employers the right to veto their employees' health insurance coverage of contraception. I mean, I think that's a bizarre claim. My claim is that the employer basically says that the right that I have is not to supply you with the particular coverage in question. It's not to veto your ability to get it from any other source. So let's just see what it really is to veto. And so I now become the master of a new religion, and it turns out that I happen to believe that total abstention for all women before marriage is a moral imperative, and that sex in marriage should only be aimed at respect to procreation. So I'm one of your reasonable kinds of modest gods, right? Me, the Catholic. And what I do is I basically pass a law which requires that to take place. You can do that by legislation. There is no way that you can do that by contract. And the key feature to understand is that when you start using the word veto in this particular sentence, you are being completely incautious, completely inexact, and completely erroneous about what a veto really is. Because this only says, I can veto my giving you the money. It doesn't say you can't get it from anywhere else. And so long as you have the exit right, you are not a slave. So long as they don't have an exit right, it's going to create many more coercive complications on the other side of the transaction than it can. So let me sort of make it finally very clear that in making these kinds of statements, I'm making a statement about liberty. I'm making a statement about how contracts work. I'm making a statement about what I think about the anti-discrimination laws. What I am not making is any statement about how I as an employer would act if this particular choice were placed upon me. And there's a completely different kinds of questions. For all you may know, I'm a really liberal kind of guy. And well, how can I establish that? Well, take another debate. I've always been a defender of same-sex marriage because I think if the state has a monopoly power over licensing, it has to give it out on fair and equal terms to all comers. The very point that I talked about with common carriers. And I am a fierce opponent of the use of a general form of anti-discrimination laws which makes sexual orientation a protected category, because I just don't want to compound the errors on the other side. So if you keep your mind on liberty in a clear sense, and understand that the only way in which you can vary from liberty in a clear sense is to respond to monopoly institutions, it becomes clear that this particular document is wrong on every point of principle, and although I won't talk about it now, manages to misread every single case on which it relies. But I'll save that discussion for later. Thank you. Thank you.
I have to steal your mic.
Oh no, just my thumb.
I actually think liberty of contract is a great way to look at this issue because of my concerns about notice in this situation. What do employees know when they decide that they're going to enroll in an institution or accept employment at a Catholic-affiliated institution? And the debate has been marked to me by a lot of stereotyping of Catholic-affiliated institutions and Catholics, and a lot of misunderstanding of Catholic theology and how Catholicism works, and how Catholic-affiliated educational institutions operate and social service agencies. And what we're seeing, it seems to me, is a demand to be able to participate in the market, in selling services like education, in taking government grants in order to provide services, without meeting the kinds of standards that are meant to protect all of us. And the employment relationship is a standard one that the government regulates. And there's good reason for that, is that there's a power imbalance there. And while no particular employer may have a monopoly, an employer does in most situations, because of the way our healthcare is set up in the United States, because we do not have, like other industrialized nations, government-provided healthcare. Your employer is often functionally a monopolist in terms of where you can get your health insurance, and some of that will be changing, but functionally, if you're not getting it from your school or your employer, you don't have other cost-effective options. An important thing on the issue of notice and consent, and why I think we're particularly well-positioned to think about this here at Fordham, is what do we sign up for? And what's happening right now is statements have been made in the media that are a current interpretation of Catholic doctrine, one particular idea that Catholicism forbids covering health insurance, covering contraception, basically without an inquiry into the reasons why you're using it. So if you look at the complaints in these cases, they're often quite explicit. Notre Dame is them when they say, we don't have an objection to covering contraception. What we have an objection to is covering contraception if it's going to be used for the purpose of preventing pregnancy. But the way you get to that coverage, non-coverage distinction is somebody has to make a determination about the reasons you are using a particular medication, why your doctor has prescribed it, whether the condition is severe enough, whether it's justifiable, and there has not been any clarity about whether this would be a theological authority or a health provider or your boss or who would make this determination. And it is discriminatory in that, and the students at Notre Dame have pointed this out, their plan covers Viagra without that inquiry. Contraception and Viagra are both the drugs that you could use for permissible Catholic purposes. You could be using it to treat a condition. You could be using it for, you can use Viagra for procreative sex that would absolutely, in a marriage, in keeping with the Catholic teaching. And you can also use contraception for reasons that are clearly fine according to official Catholic teaching. But for some reason, we're going to have an inquiry when it's a drug that women are using and not when it's something that men are using. In thinking about what we're coercing employers to do, I think that they do have the option to opt out. They could say, we're going to take an exception under Title VII. We're a religious organization, so we're going to discriminate on the basis of religious belief. But that's not something these institutions are doing. And I think it's because that's not what we are actually about. We're not about discrimination. We're not about indoctrinating people with Catholic dogma. And we have a theology department. We have scholars. We have philosophers. This is a reason people go to places like Notre Dame or Fordham or Belmont Abbey, is because they want to think about these issues. And it's not true that Catholics are beholden to whatever the bishops say. And that is, in fact, seems to me to be an internalization of what was historically a very anti-Catholic idea, the idea of the Catholic as the papist who's beholden to the Pope in Rome, this anti-democratic figure that's foreign, and this is why you have John F. Kennedy having to prove to the country that he won't be controlled by someone other than the voters. And this idea that's been accepted by the media is not sound as a matter of Catholicism, where there is authority that comes from theologians, that comes from the laity, and also from the bishops. And what you can end up doing, especially when you rely entirely on the right of exit, is you have the state essentially codifying these structures wherein a particular voice is accepted as authoritative within a religion or a culture. And that does begin to become an establishment clause problem. And I think the reason we need the government to intervene in this situation, there are a number, but one that also has a theological side to it is that there's pressure that Catholic universities are under that come from off campus, and it can be, the law can be a moderating force where perhaps the values of the institution, to the extent that there are shared values, as in the case of contraception, where we have these two cases in New York and California that have been, where they have contraceptive coverage mandates there, and those were both challenged in court by Catholic institutions, and they were upheld, and the Supreme Court denied cert, and that has relevance as a matter of Catholic theology, that you're doing something under duress. So I want to go over the legal questions here. So these cases are being brought on First Amendment grounds and also Religious Freedom Restoration Act grounds. So for a Religious Freedom Restoration Act challenge, you need to show that you have a sincere religious belief, that belief is being substantially burdened, and then if you show that, the burden switches to the government to show that they have a compelling interest and it's narrowly tailored. And what's interesting when you look at the complaints in these cases is that they haven't identified who the person is under RFRA that has this sincere religious belief that's being substantially burdened. So my favorite thing in the Notre Dame complaint is they sometimes talk about Notre Dame as having a conscience, singular, and other times talk about having consciences, plural. So we're confused about whether the corporation is what has a religious belief, or some collection of human persons who are represented by the organization. And back to the contractual issue, we need to know who that is before we decide that we're going to enroll or accept employment. And the other concern is I don't believe that they've pled a sincere religious belief in these cases. In the Catholic tradition, there's a right to health care. And what we're seeing pled is a long-standing opposition to birth control, which is not historically quite that simple. But we haven't gotten to the next step of this very attenuated involvement with healthcare, where we are. It's a form of compensation, which is regularly regulated by the government, and some individual choice, a series of them, could lead to something that is against a teaching that's been widely rejected by Catholics. So the Catholic issues are very interesting to me for various reasons, but I think we here at Fordham know that it's not even about making our peers adhere to or justify these policies on the basis of Catholic teaching, but I also think that they're being misrepresented. I think we'll leave it at that.
Thank you. A couple of observations to make. There are several kinds of objections that she raises. One kind of objection is sort of what you call internal to the law of contract, and that would include the particular charges that do not give sufficient notice of the norms in question or the expectations in question. So people are bound by a set of things that they did not assent to. I think that's a very dangerous argument to make, because what you do is you realize that these are all contracts at will. And what you announce is that effective such and such a time, this is now clearly a true expectation if it wasn't already. And in event, insists that if there's any remedy, it's the cost damages, it's certainly not specific performance. And I think that case turns out in general to be more or less a dead reach. I don't think those actions are going to be sustained. I think it's equally dangerous to sort of make this as a parity argument between men and women, because I assure you that if the Catholic Church, which is more or less adamant on this thing, we're told that it would have to give up coverage for Viagra in order to give up coverage with respect to contraceptives, they would take it in between. I might also add that if you actually look at the current distribution of health care benefits, particularly for people in, say, the 30 to 45-year age range, current law, wrongly in my view, requires that you have sex-blind rules with respect to compensation on these things. And in fact, there's an implicit transfer of wealth, since women's health care is more expensive in this period than is male health care from men to women. So if there's any kind of financial discrimination, it actually runs in the opposite direction. I think, in effect, that they should be able to set up separate tables. I know that when the cases on this topic came up in around 1980 and so forth, the position that you're allowed to basically require cost-justified pricing for each item, which is the efficient way to do things, was treated as the equivalent of Dred Scott. So it's not as though one found here a hugely sympathetic view towards what I've said. The last thing is you can't possibly win this game by saying, I don't know who the employer is. Look on the paycheck and you will find it. And then, as a matter of religious doctrine, there are a couple of points to remember. One is that whenever the courts get themselves involved in these things, they have made it a very conscious effort that the church speaks in its own voice, and the internal confusions, if any, that it has with respect to doctrine and power are for it to resolve and not for us. That goes back to the Dartmouth College case when there were fights amongst the various Congregationalists, and it's a bedrock principle, and in fact it is exactly the right principle. We do not want our civic institutions being embroiled in religious kinds of things. So nobody wants to get this thing to turn on whether or not the law school is part of the university and the dean is acting ultra virus to his boss or something of the sort. So then you go to the sort of doctrinal issues. And there are these two decisions, California and New York, and they do come down the way which Bridgette said. And they are terribly reasoned in mind. The question here is going to be resolved not by these cases when it gets to the Supreme Court. It is going to be resolved by the question of whether or not the decision that they made in the Unemployment Bureau, whatever it was, offices against Smith in 1990, survives the Hosanna-Tabor decision on religious liberty. That will be where the rubber hits the road. Myself, I think that the Scalia opinion written, which says that any neutral law can apply to black, white, religious or non-religious, so long as, well, regardless of whether it has a disparate impact, is one of the most terrible judicial decisions ever to come down. This is a rule which says that if the Army decides that pork is the meat of choice for all of its recruits, it can force Muslims and Jews to eat this under pain of civil sanction. The alternative view says, you know, you really can't play that kind of game. If it's going to cost you a little more in order to get some lamb or some other kind of meat in there, you do it. In fact, the military understands this principle well, and the only kind thing that you can say about the decision in Smith is that most government agencies understand that it's a suicide mission to try to enforce it, so they make all of the accommodations in any event. I regard the decision as a complete disgrace. The reason we had the Religious Restoration Act is that the civil libertarians and the religious groups came together and said that this is an intolerable intrusion in the way in which the public or private agencies work. And they try to get rid of it. The first time in the city of Borneo, they weren't allowed to do it. Then when they narrowed it, what's happened is the lower courts and implicitly the Supreme Court have now magically said that it is constitutional, and all subsequent litigation has gone on the view that we can switch from basically the neutrality principle to a strict scrutiny principle, which is what these legislations do, meaning you flipped everything over. Hosanna-Tabor essentially follows that. This was the decision, and what they announced there was that if you are a religious institution and some teacher comes in and says that she should be allowed to do so, and you say you're part of a calling, you cannot apply the Americans with Disability Act to force them to reinstate them if in fact they think they're part of their religious tradition. The opinion, in fact, spends one sentence talking about Smith, and it's basically the back of the hand treatment with respect to it, say that was concerned with physical invasions, i.e. taking drugs. It wasn't concerned with management type decisions. It's a stupid decision worthy of the Supreme Court on its bad days. But in effect, there's no question that on that ridiculous line, that the decision of whether or not to supply health care to various types of individuals will certainly be on the administrative side rather than on the physical invasion side. Our worthy professors have basically written a letter on this thing explaining why it is that this case is easily dismissible, because the case merely held that a house of worship, I'm going to quote from this, is exempt from certain employment laws when hiring and firing ministers. That's absolutely wrong. The anti-discrimination laws apply not only to hiring and firing, they apply to any and all conditions of employment associated with it. This was an attack on the ADA, it was not an attack on one little prong of it, and it has equal force with respect to differential treatment in there. The religious institution, I think, will in fact trump if this is correct. What bothers me so much about this inept letter is that it never once acknowledges that there's an argument on the other side with any of these things. It's bad enough that it's completely wrong and erroneous on every point of law that it addressed, but it's even worse that it doesn't bother to say, hey, the opposition puts this and this is our reputation with respect to it. And so I regard this as kind of a tragic denouement. My own prediction on this case is that Hosanna-Tabor was unanimous. I think that the religious institutions will not have their sincerity doubted in open court, and that what will happen is that this particular provision will be struck down, and it doesn't matter whether we say you can't provide it directly, but you have to buy an insurance company to do it. I'm not a great fan of the Obama administration, as any of you who have ever read anything I've written will know, but I think when it comes to disingenuous behavior, this one absolutely tops the pump. And I find it really very distressing to be in a position or I'm told that I'm an aggressor, when in fact I think I'm being attacked. That is, I think the war is being waged in the opposite direction, and that disengagement on both sides will be fine. I don't think the Catholic Church can tell women what they can do if they don't want to work for them. I think they'd be completely ill-advised to do so. In fact, when they do work for them, I think the Church basically understands the prudential message and is not trying to basically say that Fordham Law School must have all of its women students comply with its own moral dictates, right? As best I can tell, there's the Orthodox view in this particular room. I think they don't have to read a Catholic doctrine in order to attend. My view about it is people who run these institutions are not systematically retarded in the way in which they behave. And that unless you give some discretion to people with responsibility in the way in which they operate their institutions, what you will do is get ignorant governments with coercive behaviors, making life miserable for us.
I do think it's a parity issue, and I think the idea that women, their healthcare costs more, and that somehow it's a special benefit for us. Students, the idea that that healthcare is based on the model of the male body, that's what's standard, and so other things are extra. And it works out to be a salary difference because it's a form of compensation, and women's needs aren't being taken care of in the same way that men's needs are. The sincere religious belief the courts aren't going to go look into the validity of the belief, but I think that they should, although they are. They don't want to, and they usually don't. But I think in these cases, you can really look at has it even been pled? Because they're making sort of generalized comments about how some Catholics feel about birth control. But I also think that there should be a finding of fact there in terms of the sincere religious belief. If you were covering contraception until the ACA passed, that is a good reason to doubt the sincerity of your belief. If what happened was the bishop called you up and suddenly your plan changed, which I think is happening, and in a number of these cases, that's exactly what's going on, is that there was coverage that was taken away once the ACA passed. In the case of the Belmont Abbey case, which is the case that's on appeal, so the case that's on appeal is Wheaton, which is a Christian but not Catholic college, and Belmont. Belmont is a Catholic college. Their employees sued them because they had their coverage taken away. So this is not the sort of thing that's so black and white that people know that this should be what they're getting into when they go to a Catholic institution. And what I'm saying employees aren't on notice from is the idea that this institution is so religious that I should expect not to have the general protections of employment law. And there are ways, and those institutions, if that's what you want to be, you can do that, and you cannot be forced to have this. And there is a religious exemption already for groups that are their purpose is to inculcate religious values. Primarily employs persons who share its religious tenets, primarily serves persons who share its religious tenets, and is a non-profit organization with a particular tax status. And if that's what you want to be, then that is what these organizations can do. They can, and I think the problem here, the reason you couldn't solve this entirely by notice, is that you would need the employee to essentially consent to not have the protections of the generally applicable employment law based on whatever trend is going on with the bishops. Because what we're saying now is you can't even rely on generally accepted Catholic doctrine. So if we're saying there's one authoritative voice and it's off campus, then we should set that up, and you should know that that's who you are contracting with. And so quickly on Hosanna Tabor, I do think that's a ministerial exception case. That's a teacher who had a particular clerical status and did not go through the organization's procedures for dealing with a dispute that they would require somebody who had a particular ministerial function. I am not a minister at Fordham University. I do not serve any kind of ministerial function. So I can't anticipate that my conduct might be limited in the same way. And I haven't consented to that in the same way that someone who joins a church does. And a church, I'm not saying no corporations have religious beliefs, but I think that it's different in the case of a church because it represents human beings. And those human beings have the option to leave the church. And that right of exit is different than saying, okay, now that I've given 20 years of my career to this theology department, they're now controlling me in ways that I don't accept, so I can just quit. That's not the same ease of exit as you have where you can switch parishes. So I think that is a significant problem. And if you choose to work for a church, because churches are exempted with their employees, I think it's unfortunate for a janitor or someone who doesn't have a ministerial function and may not have endless job opportunities in wherever the case may be. But when you choose to work for a church, you have a different understanding of what that function is and what you are potentially, how you might be limited. So I think that as a matter of notice and consent, it's a different situation when you're talking about a church. And as far as Smith, which is the peyote case, I just want to point out that it's not just a taking drugs case. It was essentially these worshipers' form of communion. And it is a very harsh result, and nobody likes Smith. But there are reasons that Justice Scalia points out that we have such a harsh rule, even if it maybe has a bad result for minority religions, because the political process is what Justice Scalia says is the solution. This is not the case with the contraceptive coverage mandate. The political process has brought us this, and it's opposed by a group that is not a minority religion, or at least opposed by people who claim to speak for members of that religion, even if the people who consider themselves adherents don't accept this particular teaching.
Great question.
Thank you very much, Professor Epstein and Ms. Dunlap. We now have some time for questions and answers. Anyone have a question? Okay, Ryan?
So just bear with me for a moment. I wrote down this question because I wanted to be sure that I got it just right. Professor, you spoke a lot about freedom of exit, and I was wondering how you reconcile that with labor and employment laws regarding things like wages, working hours, and working conditions. And whether you believe that an employer should be allowed to pay an employee whatever he wants and have them work as many hours as they want and under any conditions that they want, as long as the employee is allowed to quit.
You got it. But you simply do not understand the power of the quit option. You start looking back at the days before the regulations started to take place, and this is what you find. You find one case in 10 where the question is whether an employee quits or whether he's fired. But in fact, most of the time, the quit option when you're faced as an employer is one that you dread because you have to hire somebody else. So you bid up the wages. And in fact, it's a very powerful lockstep progression between wages in an open market and levels of productivity. And in the period, in the progressive period, when all these laws were under vicious attack, the lack of minimum wage, maximum hour laws, that was the period of the greatest wage increases that we had, much greater than we are today. What you do today is you got all sorts of protections, but you don't get jobs. The reason you don't get jobs is because the gains from trade are eroded by this silly and inane regulation. The single protection that is worth more than every single protective law that you can mention anywhere in the history of the world is the right to enter and exit. Because what happens is that this employer is doing what you said he was, trying to push the wages down to zero and push the hours up to a terminable situation. There's going to be somebody sitting next to you, for example, who will say, I can give you a better deal. And in fact, most of the time when you're running employment relationships, the question is how you price the wages that you give to your service so that they don't leave and take superior offers. I mean, I've been an administrator, I've run these situations. And in fact, the number of times that you're involved in forcing people to quit by making outrageous demands on them is the sure road to perdition, hell, and bankruptcy. It just doesn't happen that way. And one of the really sad features about the kind of New Deal paradigm is that they always assume that competition reduces the welfare of people. Contracts are a mutual gain situation, and in a competitive market, the surplus does not go to you.
Do you want to respond to that? Or?
I just want to say quickly that ultimate individual liberty is not necessarily sufficient to protect, in particular, the rights of women. And women have often been subject to private power as opposed to public power that causes their inequality. And so that's why we have what are intrusive regulations in some ways that infringe individual liberty. But it also depends what your ultimate goal is. If your goal is something like equality as opposed to necessarily wage gains, like women are going to need different protections. Only women get pregnant. If you can just fire someone for getting pregnant, women are not going to have the same opportunity to participate in society.
This is all men. The first laws that happened in Muller v. Oregon were laws of maximum hour laws and prohibitions on women engaging in certain employments in order to protect them. And Louis Brandeis, one of the more ignorant people on this stuff, basically wrote this learned brief explaining how it was that these protective laws were needed for women because they would otherwise not be, would be exploited in the workplace. It turned out in Muller itself, all the women were fired after they were protected. The Chinese men were hired in their place. And by the time you get to the 1950s, the thing that was thought to be imperative in the progressive era turns out to be flatly unconstitutional on the grounds that everybody knows that protection of these laws is not. What do we say about pregnancy? Well, yes, pregnancy is very costly, but the abuses go both ways. There are many women, they take jobs, they get pregnant, they get all their coverage, and then they quit. And so what happens is they're now net losses for the employer in question. There are other women who get pregnant who are so valuable to the firm that they bend over backwards in order to find various kinds of an arrangement. One of the things which is never talked about in dealing with employment laws is the situations where employers actually go over the top with respect to retention on women by giving daycare facilities, extra assistance, leave time, all the stuff. What you have to do to understand what's going on here is look at the typical firm and the typical packages. And the question you ask yourself, why is it that the packages always go beyond discrimination and give positive benefits to women? And the answer is because it makes sense. Now, what is that going to do? It may change the wage level so that what happens is the total package of compensation are the same. It may well have an effect on advancement level because women who take time off from the workforce maybe have a weaker attachment. But I defy anybody who looks at this stuff in any detail to find any systematic form of exploitation which means the following condition: that employers are trying to offer women contracts which leaves the women worse off than they would be otherwise, and women take it. It just doesn't happen. The great tragedy is that the standard version of labor economics that you just heard is so completely wrong that what it does is it completely colors everything in the wrong way. There are standard orthodox principles. It just does not happen that way. And if all you do is look at litigation, you're going to see the cases of an aggrieved woman coming into court and thinking that in some sense the litigation is representative of the way in which workplaces work. At this particular point in time, female wages are actually slightly higher than male wages in many markets. In the last recession, women were laid off less frequently than men, whether you measure it by age, by occupation, or educational levels, any measure that you wanted to choose. So this is not an accurate description of the world. And you can't use hypothetical, anecdotal situations to explain the way in which large social institutions.
Trying to be the president of Yahoo, ladies.
Well, I mean, that cuts the other way, right? They're willing to hire a pregnant woman and make her CEO.
Okay, next question. Sorry, in the back.
Hi, sorry. I'll leave the questions of the law to Professor Epstein, who can handle them much more readily than I can. But I wanted to speak just briefly to and ask for a little bit of follow-up on this idea that contraception as an immoral practice according to the church isn't actually the position of the church in some kind of sense, but is just the position of particular Catholics. And you mentioned JFK and his kind of tendency or his fight to separate himself from this papist level to get a certain kind of American trust. And whether or not that was either politically or religiously the right thing for him to do, certainly he wasn't arguing, and no Catholic representing the church in history has argued that the church decides doctrine via democracy. So the fact that a certain number of people subscribe to a doctrine has no bearing on whether or not that actually is doctrine. And looking at, as Professor Epstein was saying, what the religion itself defines its teachings to be, which is what the courts are inclined to do in this kind of situation, I think quite rightly. The Catechism states in 892 that all the bishops are actually divinely inspired as the successors of the apostles to teach on matters of faith and morals, and that as they speak magisterially, even on things that are not explicitly, formally, infallibly defined, this ordinary teaching the faithful are to adhere to with religious assent. Religious assent obviously being an incredibly weighty consideration there. I won't quote from it, but also at 2399 in the Catechism, contraception is explicitly banned as immoral. And Paul VI and Humanae Vitae, half a century ago at this point, which is celebrating the anniversary, specifically says that contraception or anything that interferes with the generative process is to be excluded as grave matter for mortal sin at paragraph 14 there. So the distinction, I guess, the last thing I'll say, and I'll just kind of leave this to your explanation, I'm curious what you're trying to get at with that distinction, other than that indeed many Catholics dissent from this, but that seems irrelevant to the question at hand. This distinction between Viagra you brought up also just seems a very strange in principle, because the question isn't, oh, does it affect women or does it affect men? The question is, does it or does it not contradict the teachings of the church? Viagra acts so as to help the natural reproductive process, not to keep it from fulfilling its natural purpose, and thus does not contradict any of the things I just said or the formal teachings of the church. Contraception does precisely the opposite. So I think that while one may have an effect on women and another on men, there's also contraceptives for men in all kinds of ways that would also be excluded here. But that just isn't really a relevant distinction, I don't think, between those two drugs.
Okay. Well, contraception can be used to regulate your
Sure,
period so that you can get
just to be
pregnant
clear,
with
at that point,
yeah.
Contraception isn't the term that the church would use for that. The pill or other things that could potentially be contraceptive are morally illicit, but not when used as contraception. So the term would fall.
That's not the belief I'm talking about.
Okay.
So what? First of all, so you have multiple sources of authority. There's the there are theologians. Georgetown did a great panel on this, on the theology that I invite any Catholic nerds to look at. But what I'm talking about is contraception licit. I'm talking about what's actually the claimed religious belief here has to do with insurance. And it has to do with what kind of insurance is permissible to provide, and it has to do with a claim that you need this inquiry, and the inquiry happens in the case of birth control, doesn't happen in the case of Viagra, which can also be used for all sorts of illicit purposes. And what I'm saying is that's highly debated, and this also goes to the have you pled a sincere religious belief. So Notre Dame's grad students asked the administration, please explain how covering this drug would be a problem as a matter of Catholic theology. They want to understand how, according to the doctrine of secondary effects, which I'm not qualified to explain, how is this correct? And there was a theology professor at Notre Dame who said we should take a Thomist approach to this, Thomistic, following the teachings of Thomas Aquinas, and have a reason alone argument for what we would do in this situation. And what is true as a matter of theology, who is right, is not legally relevant. What is legally relevant is that they haven't responded to their own graduate students, who they are training to be scholars in theology, and that they haven't responded to their own theology experts in saying how this is their sincere religious belief. It seems to me if you have that sincere religious belief, you would explain it to the people you are training to be theologians.
Look, you're not answering the question. The question is, do these bishops, do these graduate students speak ex cathedra? That's the term that is used. And the answer is they do not. The church encourages all sorts of dissidence to belief and argument, but the buck stops here. It's like saying the President of the United States has declared the following rule when he hasn't explained it to 3 Republican members of the Senate, and since they ask him questions and he doesn't give up an answer, it's no longer an executive order. What you have to do is not talk about the soundness of the rule or the importance of dialogical engagement. You must explain that the church is not authoritative when by its own governance structure it is. And so what these graduate students and these theologians do doesn't make the slightest bit of difference on any of these issues. And they can be 100% right. Look, I'm not a Catholic theologian. I'm not a Jewish theologian, but I know enough about Catholic theology to realize, without quoting from the Catechism and so forth, that what Mr. Hannon was one of my students at NYU said is in fact a very accurate account of what their position is. And no court should, if they did this, it would be a travesty to say, you got all these bishops, they go one way, you get this graduate student, he's a little bit smarter, he's the one who controls. So this is all irrelevant, absolutely irrelevant. And if they tell you what they think, they're Lola. Whatever Lola wants, Lola gets. It's just not right. I mean, it's nice, and you can make it as an argument point, but it cannot be a theological.
As far as I know, there's no new papal encyclical on provision of insurance.
The Catholic teaching is that you cannot cooperate with evil in any form.
I'm not going to get into the theology argument, but seriously, watch that Georgetown panel. It's excellent.
No, they may be right on theology, but they don't speak for the church. And if the church says
but
this...
we are not a church. We are a corporation.
No, but you are a church, which is incorporated.
Are we a church?
Oh, you better believe it. I mean, look, it's just, you can't basically argue theologian against ex-cathedral argument. And all of these guys, I mean, the Catholic tradition has always had internal conflict associated with it. But there is a papal authority and a line down there, and this is not like the Congregationalists, where everything comes up from the congregation. It starts from the top and goes down. And to try to beat them on the grounds of their own sincerity is, in fact, a guaranteed way to get slaughtered.
I'm not talking about that sincerity. So when people decide to go to Fordham Law School, they look up who the Jesuits are, right? And the Jesuits have a tradition of descent from the Vatican. So
That's fine.
So that's who I'm in a contractual relationship with.
No, you're
Is Fordham University. Now, on the question of are we a church at Fordham University, I want to make a point about the New York State Constitution. The New York State Constitution prohibits the taxpayer money going to any educational institution that's controlled in whole or in part by any religious denomination. And that is a little Fordham history. So back in, I think, like 1971, all the private universities in New York State are doing poorly. And a decision was made, we got to get some money to these institutions. But we've got a problem in the New York State Constitution. It forbids taxpayer money going to somewhere that's controlled or in whole or in part by a religious denomination. So there was a great study done on what Fordham would need to do to become a non-denominational organization. And there's a distinction between studying Catholicism, which is the sort of thing that we do at a university, and indoctrinating people in Catholicism. And one is an establishment clause problem, and one is a New York State law problem, and studying Catholicism is not that kind of problem. So when we say that our health center policies are going to be according to the Catholic healthcare directives that are promulgated by the U.S. Conference of Catholic Bishops, that is problematic. And we're not the only state that has one of these provisions, because we don't want to be funding organizations that are indoctrinating people in any faith.
Really?
The taxpayer money?
Well, I mean, the problem with the argument is the taxpayer money comes from people who believe in faith. The correct argument is to say you do not want religious organizations to get from the public corpus any larger share of the institutional money than everybody else does. But it doesn't follow that, therefore, religious people have to subsidize non-religious institutions and you don't have to pay anything towards them. The correct answer in all these cases is to make sure that the balance of influence and power that would exist in a non-tax world exists here. And if you start imposing these kinds of conditions, you run into the doctrine of unconstitutional conditions, where the state with its monopoly power is favoring one side over the other. So I would argue all those conditions are unconstitutional.
I think we're going to move on to one or two more questions. There. Second row.
Professor Epstein, you stated that you consider the exemption in the ACA for religious institutions to be an unconstitutional establishment of religion problem. I was wondering if that means...
The limitation on free exercise,
I mean, you said establishment.
Oh, I said it's always a problem that somebody will raise, but I think it goes the other. Go ahead, finish the question.
Well, so you don't say...
No, what I said is there's always a bind that you can make the arguments both ways. If you exempt its establishment, and if you don't, it's free exercise. So you never want a doctrine to have a basic understanding of how freedom of association works, so that the only way you can escape one constitutional violation is to have another. That's what I said. Slightly different.
So if you think it's establishment question, I'm not going to...
I think it's potentially.
Well, no, it is potentially an establishment problem, but it's also potentially a free exercise problem. And the difficulty is, once you get away from freedom of contract, every time you want to preserve religious liberty, you're giving them something you don't give to other organizations. That's the establishment. But every time you make them follow the general rule, that's the infringement on free exercise. So what happens is the anti-discrimination laws, as a general matter, put you in an impossible position. If you have the common law rule that we could associate and not associate our free will and pleasure, absent the common carrier problem, then in effect, when a religious institution says we won't do this, it's just as exercising a religion in religious context, a liberty that's given to everybody else. And so it's not asking for a preference, it's doing. And since they're not asking for anything special, there's no establishment problem on it. It's when you put the anti-discrimination laws in place, and you put the Social Security laws in place, and you put the labor laws in place, and you get rid of the common law background, that's when you get to this kind of tightrope problem. And the way in which they tend to solve it is either through artificial distinctions, or they start giving extreme deference. So whether, for example, it turns out for religious reasons, an English person need not contribute to Social Security so long as he doesn't take money out of Social Security. But on the other hand, he's going to be forced to contribute money for his Amish employees, even though they refuse to take money coming out of it. That turns out to be the law. And that's a kind of an absurdity, as far as I can see, and that's the direct consequence of this sort of constant pending. I just want to say one other thing where I actually do agree with Bridgette, which is the question about Hosanna Tabor, though not argued here, whether or not it's a ministerial exception case or not a ministerial exception case, or how far it goes, is in fact going to be a central issue, I think, when this thing gets argued. My own view about it is that the reason it's a weak opinion is that I can't see on freedom of association grounds any reason why the called people and the lay people should be treated any differently. And I think it's for the organization to decide how they're going to be treated. But the court is not a libertarian court. And so what it's doing is it's carving out exceptions. And it will carve them out more narrowly, I think, perhaps than I want. But the answer is it wasn't before them the last time. And the question is which way it's going to go is, I think, very much an open question. The arguments that we're giving here are ridiculous, but the one that Bridgette makes is much stronger.
Okay, I think we have time for one last question. Sam?
So it seems like the question at hand is sort of for both of you as well. Is why should religious institutions be exempt from government's protected restriction on freedom to contract?
The freedom of what?
Freedom of contract and association. Basically, when the government says you have to provide this care, that's sort of a restriction of what you can provide your contract to. So the question is, why should religious institutions be exempt from it? So given the fact that some religions may seem less legitimate and have beliefs that impose seemingly arbitrary restrictions on medical care, for example, the Scientologists' opposition to psychology, Christian Scientists tend to rely on prayers for medical care. How do we address the problem of what is an acceptable religion and what is an acceptable restriction on medical care? So if I stand for the Church Compliance to Getting Healthcare, and we are opposed to all or most medical treatment because I want to save money, where do we draw the line for what is an acceptable religious institution and what is an acceptable restriction?
Well, I don't think it's about what's acceptable. There's no, there's not an inquiry into the validity of the belief. So if it's sincere religious belief in the dictates of the flying spaghetti monster, I think under RCRA, that's legitimate. And it's interesting that the exemption for churches from the contraceptive coverage mandate, the rationale was more about church autonomy than it was religious freedom. Because I think it's different when you have that kind of group where you consented to whatever it is that the organization is going to engage in. And I think that's why the distinction in Hosanna Tabor is legitimate between called people and lay people. Because there's a different level of consent to be governed by religious dictates. So I don't think we should be making distinctions between which religions are valid or not valid.
But there's a famous case on this called In Re Ballard from about 1944, in which the question of whether crank groups count as religions or crank. And in the end, as Bridgette said, they didn't want to get into the religious battle, but there was always the question of whether this was a sham. Because somebody out there who claims to be the member of an exotic religion gets lots of money from people on the promise of faith and then absconds and goes somewhere else. And their concern was that you cannot use religion as a facade in order to commit ordinary forms of common fraud. And so you have to examine what's going on. And then as religions become more complicated and more diverse, and they start spending their things on rather different things, including palaces for their leaders and so forth, that line becomes tested. The other question is, how do you do the balance? And what Bridgette said is a common expression, but it's an exact expression, which is it's a different kind of consent if you're a lay person as opposed to being a called person. The kind of consent is identical in the two cases. What you do is you tell somebody, if you wish to work with me, we will not supply you contraceptive services as part of our employment coverage, whether we do it by self-administration or pay some third party to do it. And if the two guys said, yes, I understand, I won't do it, and I'll get my contraceptive care somewhere else out of my own funds or whatever it is, that's the full level of consent. The reason the issue becomes so problematic under the current is that when you're trying to figure out a balance between an anti-discrimination law and a free exercise clause, There's a long tradition going back to cases like Roberts against the JC, where Justice Brennan, who speaks on all sides of all issues simultaneously, said, look, I think that freedom of association is actually dominant with respect to intimate association. So the law cannot impose upon me the rule that I cannot refuse to marry Bridgette on the grounds that she's not sugar fine, because it's a different thing from the employment situation. And Brennan was on that. And then when he said, when you're dealing with fraternal or maternal or any other kind of organization, we don't follow the principle of freedom of association. But he said, under those circumstances, what we do is we have the anti-discrimination law trumps the freedom of contract question. Right? Well, now you're starting to the case where it can trump it or not trump it. When you put something on the other side of the balance, what Bridgette said is in fact the correct analysis argument. She says, look, I mean, you're putting something really heavy on this side. You're talking about essential people or vital rituals, the peyote case, or your church personnel. But if you're just talking about the janitors, then in effect it's less important, and so we run the balance in the other way. My own view about it is we learn to load balancing when there's no need for it. And that trying to figure out when you have complex institutions with multiple levels of employee, which way the balance goes. It should not be necessary in a world in which you have market institutions. But it will be the decisive issue before the court, and people like myself will write lonely briefs saying, this is a fool's enterprise. You ought not to go down this path. You ought to understand that all your jurisprudence on this subject is completely unsound, and we will be laughed out of court. One of the characteristics of modern Supreme Court adjudication on every issue that I work in is you are not allowed before that group of august 9 individuals to raise any questions of first principle in order to deal with whatever turns out to be the weakness or strengths of their argument. And so whether you're talking about takings laws, sovereign immunity, employment discrimination law, you name it, everything is essentially in the Supreme Court Beltway jurisprudence. And I think that's the way this case is going to go. Which way will it be decided? I don't know. I think the regulations will be struck down, but it won't be the last word because they'll be given an opportunity to draft some other regulations. But right now, the great tragedy is if you take the regulations that Bridgette read to you, essentially a Catholic hospital, in order to preserve its exemptions, right, from the statute, has to turn down taking any non-Catholic people. A parochial school can no longer serve Protestant students. And I mean, forcing people to that kind of alternative. Boy, you want to find something that's unconscionable as a matter of law. Why would you want to take a benevolent organization and force them out of charitable businesses so that you can have your views of contraception rammed down their throat? It seems to me to be the most unconscionable.
I think that's the...
Correct. Read the regulation.
It's a disingenuous argument that we're going to quit serving people. We still have Catholic hospitals in New York and in California. We still have homeless shelters. And not all of them are self-insured. But back to the ministerial exception, it's important to make those distinctions precisely because, yes, the Catholic Church is not a democracy. So we need to find a way to let anti-democratic institutions exist within certain boundaries where people choose to be governed by them. But we need the government to set certain thresholds so that those who do not consent to the religion are not being controlled by anti-democratic principles against their will. So I think that's why.
Let me give you an example of what did happen. There was famous litigation brought by the Civil Liberties Union against the City of New York on the question of whether or not it was permissible for the City of New York to give money to Catholic institutions for foster care if, in fact, the Catholic institutions did not instruct the young men and women in their charge on birth control. And this was brought by Bert Newborn, the ACLU, against FAO Schwartz, the city, and they agreed on a settlement. The Catholic Church was not allowed to participate in the litigation, in which they said, you know, it really is an establishment clause violation. What the Catholic Church did is said, we will not join your foster care program because we can't teach it. And so it was no longer possible for them to give the kind of care that the parents were quite willing to have them do because they didn't do it. We're not going to talk about this as it might happen. It has happened already. It is an insane use of government power to take people who want to give benevolence and say you can only give it on our terms. If you want somebody else who doesn't want that care, There are Protestant, Presbyterian, Jewish, gay organizations that will do it, and the protection is a multiplicity of organizations. It is not in beating them to a pulp. And look, my view about it is if the various gay organizations have rules on their internal governance, no Catholic can tell them how to run. And all voluntary organizations should run by unanimous consent and exit. None should have to be forced to yield to these kinds of quasi-democratic principles where somebody outside them tells them what the minimum standards they have to comply. You have to worry about the real difference between tyranny on the one hand and freedom on the other. And it's just too easy to get on the wrong side of that line because you're so sure you're right.
I think that the same-sex adoption is an interesting case because that's another situation where the organizations themselves wanted to place children with these couples and were doing it, and bishops called them up and told them to stop. So there are other coercive forces at work here, and we need regulations that balance out some of these issues. And the claims are continuing, and now we're having situations where women are getting fired for using in vitro fertilization. We have situations where women are getting fired for having basically for keeping their pregnancies when they get pregnant out of wedlock. But what we also have for keeping them, for being pregnant out of wedlock, you can lose your job at a Catholic school. Now, and the other thing, the other side of this though is with like the bishop sex trafficking programs, where they wouldn't talk about contraception, and they lost their funding, and they considered losing their government funding because they couldn't meet the generally applicable standard, a terrible religious freedom violation. So we're seeing an assertion of Catholic power. It's not about I just want to be left alone. It's I want to participate in the public sphere. I want to benefit from a secular state. I want to be, a prestigious university, but also get to use our religious beliefs as a sword whenever I want to.
But they're not using it as a sword. Suppose it turns out there's another group that says we specialize in same-sex adoption. I would much rather them do it than the Catholic Church do it. And this is the issue. We keep assuming that these guys are the only game in town when they're not. I am violently against them when they try to impose their views on non-religious organizations and completely with them when they want to mind their own business in their own way. And you want a world in which everybody agrees with you. I want a world in which people can decide for themselves even when they disagree with me. Your position becomes the intolerant one because there's one way or another. My position lets different organizations decide different things. And I think it is absolutely vital that we maintain this decision. Because otherwise, everything is vote against vote. Now, when these guys win their next election, what they're going to do is they're going to put Planned Parenthood out of business because they essentially engage in more moral activity. You just have to recognize that we're just too easy. This whole movement is too easy in using state power on the grounds that somehow we don't have to agree with them. Well, when they get in power, they'll play the same game against you. And we don't want that. I don't want the state of Minnesota paying the same-sex marriage. And I know why I don't. It's not that I'm in favor of it. It doesn't matter whether I'm in favor of it. What we have to do is to look at our own deepest moral beliefs and to recognize that they don't give us an advantage in deciding the boundaries of liberty. And that's not what we're committed to.
When the political when we vote and the political process results in policies that say government funding is not going to go to places that are treating sex trafficking victims but not allowing them to have information about reproductive health, that's legitimate. And the polity came up with how they want their tax dollars spent, and they do not want their tax dollars spent on subpar services for sex trafficking victims.
When they have the same issue the other way around, and the conservatives said that you're not allowed to give advice about abortion, you talk about prenatal care. Every liberal in town said this was an improper use of the political system. You just only see your ox being bored, you never see the other guy's ox being bored. Every group has played this on both sides, so you're defending one position all the time. What I'm trying to do is to defend a series of processes that people with fundamental disagreements can live together in a political society. And that means I can't force you, And it means that I can't take collective revenues raised by taxes and say all of it goes to my guys and none of it goes to your guys. And I don't think that you're aware of that. You just keep on saying that you like it. It's the democratic process, and when you don't like it, it's a fundamental right of abortion. When you say that the right of abortion should be limited by the political process, you really believe that Roe is wrong? I'm just saying yes or no, is Roe wrong under your view?
The result or the...
No, the fact that you can't be constitutional under your view because the polity decides that abortion is illegal.
That's not my view.
I didn't think it is. Well, remember,
Overstatement
it's
of what
sauce
I
for the
said.
goose and sauce for the gander. I think we're probably over that. That is, I think, something you have to remember. If you're going to play the Roe game, you can't play it the other way. When it turns out, if democratic policies help you, you're for them. When they hurt you, you're against them.
But there's no fundamental right to government funding
Well,
of your
wait a second.
subpart social services program.
That's one of your distinctions, but in fact what happens is you always make it conveniently, and that doesn't deal with the case where we choose not to fund those organizations that give advice about abortion. Because there's no fundamental right to fund funding, and when it came to that issue, you guys were on the other side, 100% Harrison, which is just not true. You just play the opportunistic game. When I'm right, it's a fundamental moral right. When I'm wrong, it's democratic process. I've been both. You can't be that way. You've got to have a set of values or how you lose. And you never do.
Okay, a big round of applause for our speakers. Thank you so much. Thank you, Professor Epstein. Thank you, Ms. Dunlap.
And the church makes it.
I wanted to